page 16 where the complaint starts.
Yes.
But before I just read some relevant parts of this, I'll be mindful that this relates to a very sensitive issue. But it is my duty as a senior counsel to place the facts and law as fairly as possible and assist your lordships, in a matter like this, because whatever your ladyship would decide would be chartering, at least in relation to this Telangana High Court, a course of action that needs to be followed in POCSO, which by its very nature is, a slightly serious enactment meant to curtail certain mischief. As I will read through this complaint, I'll place for your ladyships very quickly a gist and then show these parts, Complaint states, that the mother as a victim is filing a complaint saying that the mother came to learn that the daughter who is under the age of 18 years, and I will take it to be true for the purpose of my interim protection argument, because again, as I said, fairly I must assist this honorable court. Supreme Court says at the stage of bail, the court would not be at that juncture guided by these allegations about age. While I have a case about age which I will have to demonstrate later, at the stage of bail, it is my duty as a senior counsel to tell your ladyships responsibly that at a bail, your ladyship will not be looking at whether the age is correct or not. At this stage, I have to satisfy your ladyship that even if the person is below 18 years of age, I am entitled to maybe grant of an anticipatory bail in future, because if I come to that threshold, only then your ladyship would consider granting me interim protection today. So, my lord, what this complaint therefore says is, the mother comes to know that June of last year, the daughter entered into a relationship. This is very important. Now, my lord, the mother says there was a relationship the daughter entered into in the June of last year. The mother then, my lord, refers to 4 incidents. My lord, one incident in the basement of their house, October, November, without giving a specific date. My lord, the second incident that they refer to is 25th October, which is in para 5, my lords. The third incident, my lord, they referred at page 17, again, my lord, the same para, is 13th November. My lord, ladyship may just note these 4 dates: October, November, 25th October, 13th November, and my lord, the most serious allegation they make is in relation to para 6, which is, my lord, on 31st December of last year.
Where is 13th November? I don't
yes, no, 13th yes. November, page 17.
Yes. And then 31st December.
31st December is at page 16. Lord, what I want to tell your ladyship is, in relation to each of these incidents I had indicated yesterday, that prior to and post each of these incidents, the daughter was in a very cordial relationship, my lord, with the accused. Messages would show, my lord, that they were exchanging these messages on a regular basis. There were telephone calls that stretched for 8 hours, 10 hours in one particular case. They spoke through the night. None of those messages will show that there was any issue relating to any part of the conduct. The ladyship may take it from me. The allegations are, my lord, of penetrative sexual assault. We are not accepting any of such allegations. Lord, my respectful submission is, though, my lord, we are taking that particular stand, when I have to seek interim protection, I must start with the complaint and say, even if the complaint is true, this would not be a case which would require me to be subjected to arrest immediately. But not with this background, if I may just show para 3 straight away. My lord, para 3 mentions, my lord, about a relationship starting. I'm sorry, para 2.
Yes.
June 2025, your ladyship will see that date in para 2. Para 3, my lord, mentions accused deliberately built trust with my daughter, induced her into a relationship. Lord, I just wanted your ladyship to mark that expression, into a relationship. My lord, then, after making allegations of continuous psychological control, including restricting her educational decisions, Lord, please mark the next expression, isolating her from independent choices. My lord, then para 4, my lord, makes further allegations that, my lord, he has sent messages from time to time expressing remorse and, my lord, expressing regrets for hurting her. Lord, I have gone through the messages to the extent I could trace. I could tell your ladyship clearly, my lord, that we will be able to show it to your ladyship. This is, my lord, in a relationship, my lord, when one person, they have a fight, if someone is fighting with some other person, if someone thinks they have hurt the other person, if someone is expressing hurt, my lord, expressing regrets for hurt caused, this is hurt caused emotionally in a relationship that happens, and your ladyship knows, my lord, this would not mean that any offense under POCSO is made out, nor would those messages indicate that this person expressing regret, my lord, in relation to the hurt caused would be determinative of any POXO offense related conduct. My lord, then para 5 your ladyship saw. First paragraph refers to, my lord, the first incident. It says, my daughter disclosed it previously in my own apartment at the basement between October or November. He tried to, your ladyship may just read this part, but I just don't want to read this because that one sentence your ladyship may see, in spite of a resistance. Then, my lord, and on on 25th October 25 at midnight, he took my daughter to Golf View Apartments located at Nanakram Guda along with 2 other friends. But this is very important. There are 2 other persons, my lord, who were also present. And then, my lord, so and so, ladyship may see that next sentence. For a stay of 2 to 3 days. So, my lord, in the second incident, the allegation is the daughter was taken to stay with, my lord, my client for a period of 2 to 3 days. The ladyship will singularly notice in those 2 to 3 days, my lord, the daughter did not take away the phone from the daughter, even according to the mother. The daughter was in free communication. She had her telephone and she chose to stay away for 2 to 3 days. My lord, next further. And my lord, the last sentence, your ladyship may notice on that particular part, post for so and so acts. Asking my daughter, my lord, next sentence, page 17, and then forced her, my lord, I'm not reading it, not that I'm omitting it. I'm requesting your ladyship to see the first line. Forced her for a sleepover despite her resistance. Sleepover, my lord, is when they go and stay at somebody else's house. My daughter faced similar incidents at so and so farm located at Moinabad dated 13th November 2025. Similar incidents, my lord, would obviously be with regard to whatever happened, my lord, on 25th October. My lord, then para 6. During this period, my daughter was taken to a private location, including residential premises and a farmhouse. And on 31st December 25, 1st January, Ananya Farms, Moinabad. I further wish to bring to your notice a serious incident that occurred on the night of 31st December 2025, continuing into the early hours of 1st January at a farmhouse located in Moinabad. On that occasion, my minor daughter was present along with so-and-so and his friends, consisting of approximately 5 boys and 2 girls. So, my lord, they were not alone. They were in the company of at least 7 other people. My lord, then, despite her resistance, my lord, ladyship may kindly see, she was pressured to consume alcohol breezer. My lord, what I would be doing is, my lord, if your lord, ladyship would permit, because there is some material that I wanted to give to the police in the course of my aiding the investigation. There are video clips that have been taken by our friends, video clips that are present, which show, my lord, again, these are aspects I would have loved not to vilify the girl. Today, my lord, lordship may kindly take it from me. There is nothing I want to do any, my lord, character impugning or anything against the daughter. I am only trying to defend an allegation made against me that I forced her to drink a breezer. The videos, if your ladyship would see, not in your ladyship's chamber, because I do not want to show anything, she freely consumes alcohol on many occasions. And she is laughing. She is in fact trying, my lord, to give it to somebody else also. Lord, then if I may read further. Thereafter, during the late night hours, approximately between 1:30 and 2:30 a.m., next part of that paragraph, my lord, I may just request your ladyship to see.
You can skip.
Yes, my lord. My lord, this is very important, my lord, because this would determine the nature of the offense in relation to which, my lord, the FIR comes to be booked. Because later on, 161 statement, my lord, they may have, because I don't have a copy of the 161 statement. There was an alteration memo.
You have the copy?
Yes, my lord. Yes, my lord. But all that I would want to say, my lord, for your ladyship's kind consideration is, taking each of these allegations to be, but for whatever worth they are to be true, then the offences that come to be registered are, my lord, aligning with these allegations. None of these allegations make any allegation, my lord, of any penetrative sexual assault my lord, in the complaint itself. Now, something is very important. My lord, 7 mentions, my lord, about severe distress and constitutes a severe act of coercion and exploitation of a minor. My lord, mental conditioning and dependency is mentioned. Next page, 8. She's, my lord, producing copies of the chat history and screenshots on record for the police to consider. My lord, then please see 9. On 7th January, my lord, this is very important. The accused abruptly terminated the relationship. Now, please mark this. So he terminated the relationship and refused to take responsibility for his actions. I further submit that on 13 January, so-and-so contacted me through messages in a state of panic, expressing concern about her condition and requesting intervention. These communications reflect his awareness of the mental trauma and distress caused to my daughter and corroborate the impact of the above incident. My lord, I just pause with your ladyship's kind permission. 13th, my lord, they say that I contacted the mother, which is true. My lord, from 1st to, my lord, this date, my lord, the messages, my lord, that I will place for your ladyship's kind consideration, requesting ladyship to see would see that the daughter never complained anything till 7th. Then 7th, my lord, for whatever reasons they may have had, he decided to break the relationship, even according to the complaint. Post 7th, my lord, the boy started receiving messages about the girl threatening to commit suicide, sending pictures of Dettol, sending pictures of crocin, Dolo tablets she wanted to consume in a bulk. He was concerned. He called the mother and father and told them, this is what your daughter is doing. Please ensure that there is someone to protect her. Please reason with her. Tell her not to take any such actions. This continued, my lord, for a length of time. And my lord, eventually, if your ladyship sees, para 10, as a direct consequence of sustained abuse and abandonment, my daughter suffered severe emotional trauma, attempted self-harm on 19th January and 26th January. But what is important, my lord, your ladyship may note today, for the purpose of the complaint, for the purpose of interim protection, there has been no reporting of this, my lord, self-harm sought to be implicated, because your lordships are aware. If someone tries to inflict self-harm, which may cause danger to their life, it's actually an offense under IPC. No FIR registered. Then para 11. Subsequently, we received credible information that so-and-so has been circulating private and personal information of my daughter and spreading defamatory statements. Now, 12 is very important, because when your ladyship are looking at the complaint, normally what happens is a particular incident may happen. A lady will be very distressed. There may be a complaint filed on the next day. Maybe, my lord, the lady is in a state of shock. So what happens? The complaint may not have all the details. So, my lord, in the sexual offences, the court gives a slightly greater latitude. My lord, unlike other offences where any improvement is viewed, my lord, with a great deal of suspicion, in sexual offence related matters, my lord, the court gives a slight latitude where a quick statement following next day or any other day, my lord, the court will not discard it right away. But when your lordships are going to see, my lord, from this complaint itself, that they, after becoming aware, and they're talking, my lord, the daughter trying to take serious steps in the month of January and February, they contemplated legal action. Now, please see 12. When we initiated to seek legal remedy in March 2026, this is important, we began receiving calls and indirect pressure to withdraw the matter. But after this, my lord, they mention in para 13 that when they, again, last few lines, immediately after our attempts to seek legal remedy clearly indicates a concerted effort and criminal conspiracy to derail justice. My lord, then para 14, on 22nd April, my lord, they said someone tried to mediate a settlement. My lord, ladyship may see, my lord, they mentioned that they met and my lord, this causes some fear and intimidation with them. Para 15, I respectfully submit the entire sequence of events clearly discloses offences under POCSO, wherein consent of a minor is immaterial in law. My lord, please mark this. So they are now advised in law that consent of a minor is immaterial in law, which is also not correct in terms of law what it is. Along with serious offences under BNS, including assault, criminal intimidation, defamation, and conspiracy. Now, the reason I'm pointing out this is, these are not words that come normally to a normal person. And it is very good that normal persons should learn about law, acquaint themselves well. All that I'm trying to place for my ladyship's kind consideration is, they have now, because according to them, they were confronted with the problem, they started acquainting themselves with, the legal steps. They were contemplating legal remedy in the month of March, and the usage of expression also, and them saying that consent is immaterial of a minor, indicates, that they have been now informed in law. Then 16, the Honorable Supreme Court has consistently held any sexual involvement with a minor, even under the guise of a relationship or promise of marriage. Please mark this. Again, fully advised legally that the Supreme Court says if there is under a false pretext or a false promise, someone promises and the girl enters into a relationship, my lord, indicating today, even when your ladyships are posting the matter, my lord, for an anticipatory bail. But by the way, my lord, I am ready to argue my anticipatory bail today, but I am respectfully agreeing that your ladyship may want to hear the victim. So, my lord, I am only for interview. Arguments are going to be same, my lord, in any case. So, my lord, my respectful submission is, so when the person is now mentioning here that this is what Supreme Court has said. So by the time they are filing the complaint on 8th May, they have fully informed themselves about, my lord, all the legal areas of, my lord, the legal areas that operate in this area, what is their rights. I mean, then please see 16. In view of the above, I humbly request your kind authority to initiate immediate action against so-and-so who also tried to false complaint against my daughter, and to provide appropriate protection provided to my daughter and our family to safeguard us from any further life threats in the interest of justice. I state the above facts are true to the best of my knowledge and belief. But again, these are expressions which normally used in an affidavit. So at this stage, my lord, your ladyship would notice that this would be a case where, my lord, they have been legally advised. My lord, why I stress so much on them being legally advised? This complaint comes to be filed, your ladyship notes the date on 8th May.
Yes.
8th May, which is a full 4 months after he broke the relationship, a full 4 months, 8 days after the last incident, my lord. And after they come to know on 13th January, my lord, let me assume the daughter did not tell the, my lord, parents. The parents come to know on 13th January when, according to the complaint itself, I have written, my lord, to the mother and informed the mother. Post 13th January, no, they according to them, the daughter tried to inflict some harm on herself, my lord, January end and February. They don't file any report about that. But your ladyship can start with this assumption that by then they were fully aware of what happened. If they were aware and they took legal advice in the month of March and thereafter they file a complaint on 8th May, that 8th May complaint is a product of contemplation, reflection, legal information and, my lord, legal counsel, after which they are filing the complaint. Now, my lord, in this entire complaint, the ladyship will not find any allegation of any penetrative sexual assault. They have made allegations of sexual assault. So on the basis of this FIR, my lord, the police register an FIR and the police register the FIR, my lord, under these sections. My lord, may I just pass on this chart for your ladyship? Quick reference.
It is already filed, no? Along page
Already
13.
filed. Yes. Lord, this, my lord, I am only indicating which offence is for what purpose and what extent. But in that first table, your ladyship puts 3.
74.
Everything, give copies to them. My lord, when the offence was registered, section 74, not less than 1 year may extend to 5 years. 75 BNS may extend to 3 years. Section 12 POCSO, my lord, may extend to 3 years. Offence, my lord, that comes to be added subsequently. My lord, no, this is where, my lord, I have a gripe. My grievance is, unlike a regular case, my lord, where post-assault, my lord, complaint is filed the next day or the next day thereafter. And, my lord, in a section 161 statement, and I said, my lord, there's a slight latitude only in sexual offence cases. Every other case, there is 0 latitude. Court will view it with great suspicion. But even if your ladyship want to give certain latitude to them, if such a complaint is filed, my lord, after so much of deliberation, contemplation and legal advice, referring to Supreme Court judgments, referring to consent being immaterial, referring to, my lord, the aspect that if you have taken consent under some deception, it is wrongful, but they would not miss out an important detail of penetrative sexual assault. No offence under that particular section is made out. So yesterday, my lord, I had made this argument for your ladyship's consideration. It can sometimes so happen that the complaint may attract a particular offence. But police, my lord, because they are not so well, because when they deal, my lord, no disrespect, my lord, they may have missed out adding a particular offence. But if your ladyships are going to be satisfied that from the complaint there is absolutely no allegation of penetrative sexual assault, and if the offences that are made are correctly recognized to be these offences which are all punishable under 7 years, I would have been straight away entitled to the benefit of Arnesh Kumar. Lord, I would have participated, I have assisted in the investigation, my lord, and the matters could have gone, my lord, in the way the law contemplates. Now, what they do is after they file this FIR, maybe if they thought, my lord, the notice of the FIR being given in the media would scare me and I would come around for, my lord, a settlement or whatever. If that did not happen, then they go and give a further statement. So the further statement given thereafter Not in my respectful submission is something that today
Is further statement voluntarily given or is it during the course of
161
161 statement.
161.
161 statement. My lord, these improvements that are made in 161 statement, I'll place my lord 2 or 3 judgments for your ladyship's kind consideration. The court may view it with a great deal of suspicion. But I'm putting it at the highest. I'm not saying they should be discarded. At trial, my lord, what is the veracity to be given, your ladyship may consider. But if, my lord, the law in POXO is not prohibiting the grant of an anticipatory bail, now this is something that will come into, my lord, the court's parameters of consideration, that if the original offense which you are filing after 4.5 months is not alleging any penetrative sexual assault, and if this is only providing for punishments below 7 years, can it be thought for a minute that the subsequent improvement, because by then you're already completely informed legally, a subsequent improvement, my lord, if it evokes any suspicion in your ladyship's mind, that I would respectfully pray, my lord, ladyship may have to grant me the benefit of doubt that there may be a possibility of an improvement for the limited purpose of an anticipatory bail today. Not because otherwise what it does is, it now straight away takes the category of offences from punishable below 5 years to 20 years or remainder of the remaining person's life. Please see the jump. There is a huge jump in terms of gravity that happens by way of an improvement. So that one improvement that is being done, why was this not mentioned on the day before? Especially if they have been contemplating legal steps from the month of March, especially if they are already aware of, my lord, various legal nuances in relation to a POXO case. If they are so well aware, my lord, they would not have missed out this most important detail, and that in my respectful submission throws any amount of doubt, my lord, on their deliberate attempt to frame me in such a way that I cannot but be arrested, my lord, in this particular matter. So this may amount to, in my respectful submission, an abuse of process of law, and, my lord, trying to use the process of criminal justice for a purpose which is not intended. My lord, I am taking guidance, my lord, from your, my lord, several judgments that your ladyship, my lord, this honorable court and the Supreme Court has laid down in relation to SC/ST Act. SC/ST Act, there is a textual bar on grant of anticipatory bail. But, my lord, the courts have said, look, if you are trying to ensure a person is coming under SC/ST Act for the purpose of preventing him to take an anticipatory bail, the court will look behind the complaint to see whether these incidents actually constitute that or not. My lord, I am requesting your ladyship to give me that additional leeway into the court looking into only this additional section. My lord, I am not arguing that the court needs to give me for the entire POXO Act. But if the complaint given at page 16 is taken, I will concede section 11 and 12 of the POXO Act are made out. But the improvement that is made, but in fact, if this improvement constituted a basis of the original complaint also, but I'm putting it slightly higher, my lord. Even if this improvement was a part of the original complaint, like in SC/ST Act, it's a part of the original complaint. If the court contemporaneous material, if the surrounding material excites a doubt in the mind of the court that this seems to be a contrivance for bringing it under SC/ST Act, the court says, no, we will disregard this because at this point, we will grant an anticipatory bail. So, my lord, today my respectful submission is, even if the improvement was originally a part of the complaint, if the contemporaneous, my lord, material at that particular point of time was going to raise a doubt in your ladyship's mind that this assault that they are talking is not correct, because the messages before and after, nothing is speaking about it. Even after, my lord, 6th January, nothing is speaking about it. Unless, my lord, the learned public prosecutor appearing for the police can place something else that I don't have access to right now. So, my lord, if I may now, therefore, my lord, make my point that the original complaint, all the offences correctly categorized. The improvement in what manner, I am not aware, but improvement is happening later after they have been legally counseled. So, the court may have to discard it for the purpose of interim bail. But there's a judgment, my lord, that I'll be placing very quickly. My lord, the court, while granting an anticipatory bail, tells us, my lord, when we are reading that judgment, my lord, when I say us is our lawyer community, this is not allowing someone to go scot-free. Anticipatory bail, my lord, is not like a quash. The ladyships are not quashing the complaint. My lord, if your ladyships are otherwise persuaded by our argument, should your ladyship consider granting an anticipatory bail? Whether that improvement would actually stand up to trial, whether that sections need to be charged at the stage of framing of charges, my lord, all of that, there is a different journey. Unlike a quash, where, my lord, we would pray the court to quash the offense today. So, my lord, today we are not asking for quash, we are asking for a limited benefit to be granted to us in the case of anticipatory bail. My lord, this is my argument in relation to the complaint. What I want to do, my lord, is very quickly, because the ladyships have noted the 4 dates, but I am placing this in a sealed cover and giving it to my friends in a sealed cover. In fact, I must also seek a ladyship's permission. My lord, normally when we file these cases, we redact the names. In relation to some certificates that were filed, when we have to seek your ladyship's permission for redacting.
Yes.
But unfortunately, my lord, what happens is these days, I don't know how, the moment bail petition is filed, luckily, my lord, bail petition was filed without giving the prosecutrix name and the redaction. I'm told, my lord, this bail petition has been circulated in social media with underlying and analysis. Those certificates, my lord, if your ladyship's permit, I'll ask my colleagues to redact it, and the originals, my lord, or whatever certificates we may place in a sealed cover, which a ladyship can ask the registry to keep it in a sealed cover so that, my lord, the victim's name does not come out. So, my lord, this.
I hope they have no objection to that.
My lord, certificates are very court record, photocopies, we circulate just on social media.